Abated.
I have received the instruction, Lordship. I have also received the death certificate, Lordship. And wife is there, Lordship. She is not interested, Lordship. So she also sent one letter to me, Lordship.
Uh, Pursuant to Discourse Order dated 5/11/2024, MSP Bhattacharya, Learned Counsel for the petitioner, on instruction, submits that after date of the petitioner, who died on 11/7/2024, his legal heirs, that is, wife, is not interested to pursue in this matter. Accordingly, her client has also written a letter to her along with a death certificate of the deceased petitioner. Full stop. In view of the aforesaid, the matter stands closed, being abated. The Xerox copy of the death certificate as well as letter communicated by the wife of the deceased is kept on record.
Apply, Lordship.
Petition stands closed.
Lordship, 2012 metal, Lordship, briefly. 12 metal, Lordship,
We know that.
for an adjournment, Lordship.
No.
Because there is no connection with my client.
You are no more the lawyer.
I am at the fourth petition.
Earlier, it was recorded in the order sheet that you have withdrawn from the brief.
Yes.
Huh?
But my name is shown in the.
Maybe that's all. None appears for the petitioner on call. Full stop. None appears for the parties on call. The present application is filed under section 482 of the Code of Criminal Procedure, assailing an order, judgment and order dated 02/06/2011 passed by the learned Chief Judicial Magistrate Golaghat in miss case number 02/2011 under section 125 CRPC, whereby by the respondent wife, isn't it? Respondent wife, whereby the present petitioner was directed to pay a monthly maintenance allowance of rupees 2,000 each to the son and one daughter, and rupees 8,000 2,000 each to the son and one daughter, and 8,000 to the respondent wife. Full stop. Such determination was assailed before the learned Session Judge Golaghat in criminal revision number 12/2011, and the learned Session Judge by its judgment and order dated 3/7/2012 declined to interfere with the judgment impugned in the aforesaid revision petition, and accordingly the present application is filed. Full stop. The ground urged in this present petition is that grounded the learned courts below has committed serious error of law as well as of fact in arriving at the aforesaid conclusion, more particularly for the reason that during the cross-examination, the respondent wife stated that her younger son is not residing with her and he used to reside with the second party petitioner who is studying in Madrasa at Nagaon. Therefore, in the backdrop of aforesaid admitted position, the court could not have, both the learned courts below could not have awarded the maintenance in favor of the second party. Full stop. In favor of the second party, in favor of the son. It is the further case that at the relevant point of time, the age of the son, one of the son of the petitioner, was aged more than 18 years and was staying and doing some business. And therefore, in this case also, the maintenance could not have been awarded. Similar is the case so far in respect of the oldest son, who is also who was also major at that point of time, and such evidence are available on record. And the court has concluded, arrived at the conclusion on the basis of materials. Court has arrived at a conclusion on the basis of materials which reflects a state of affair otherwise. It is a further case that the respondent wife has failed to prove the income of the present petitioner and therefore erroneously awarded the maintenance. Okay. Full stop. In the aforesaid backdrop, let this court now examine, since a perversity has been alleged, therefore this court would like to go through the evidence of the witnesses, more particularly the PW1. In her evidence, the PW1, that is the mother, deposed that the children are staying with her. Elder son appeared in metric examination, but did not, could not, was to appear in the metric examination, but could not appear. The second son was reading in class 8. She further deposed that she do not have any income for pursuing their studies. And the youngest one is reading in madrasa at Nagaon. The second party, that is the present petitioner, took the younger boy forcefully with him. She further deposed that she does not have any source of income. Boys and girls are minor. Full stop. During cross-examination, though it is asked that she has admitted the her sons to be major, however, such assertion or statement is not there in the cross-examination. What is discernible from the cross-examination is that the petitioner projected a case that the wife willfully left the house of the husband. Full stop. She deposed that younger boy is not with her and he is with second party. Full stop. Hey, I'll share this. Through the evidence of PW2, who is an independent person and a neighbor, it was established that the words of the petitioner were minor. One was around 17 years, and other one was 12 years at that relevant point of time. Similar is the position as regards the other witnesses uh, adduced by the petitioner. The present petitioner as respondent also examined himself as DW1. From his evidence, it is seen that it is his projected case that the wife has gone away from uh, parted his company on her own will. According to him, he divorced her in front of the Qazi. He deposed in his evidence that he has 3 shops which is in rent and earns rupees 900 per month from there, and had 3 bighas of land, but those were sold out. And he is having 1 car, though it is not in a running condition. And also deposed that his son Sharifuddin was doing business. During cross-examination, he asserted that that his son and daughters are staying with him. During cross-examination, he has also admitted that Datar is 15 years old and she is with her mother. Full stop. The he also adduced evidence of one Abdul Kalam as DW2. Nothing material has been deposed by this witness so far relating to award of maintenance and inability of the wife to maintain herself. Full stop. On the basis of the aforesaid material, the learned trial court after on the basis after taking note of all the aforesaid depositions and evidence available on record, concluded that the no maintenance has been provided to the petitioner by her husband. As regards age of the son to be more than 18 years, the learned trial court concluded that though it was projected that the son is above 18 years, however, no evidence was produced by the husband to support such contention. So far relating to the age of daughters, that is 14 years, and a daughter of 14 years and the youngest son to be 12 years of age, the learned court relied on the statement of the DW1 in his examination in chief, where he has admitted the aforesaid position. Accordingly, it was concluded that the 3 children of the parties are minors and therefore they are entitled to monthly maintenance. So far relating to the quantum of maintenance, the learned trial judge took note of the material evidence that the petitioner, besides having besides having rental income, was also having a truck, and he has never pleaded shortcoming of his earnings. And accordingly, a conclusion was arrived at that he is having sufficient means of income, but he fails to neglect the petitioner and his minor daughters, minor children. Accordingly, monthly maintenance of rupees 2,000 each was directed to be paid to the petitioner and to the wife and her children. Such determination was upheld by the learned session judge in criminal revision petition number 12 of 2011 and concluded that the trial court has rightly arrived at a conclusion after scrutinizing the evidence of the parties. And accordingly, noted that the courts did not find anything to interfere with the impugned judgment in exercise of its revisional jurisdiction. Full stop. The object of revisional power in exercise of revisional power under section 482 CRPC, this court can set right a patent defect or an error of jurisdiction or of law. Such power can be exercised where the decision under challenge are grossly erroneous or where there is non-compliance with the provisions of law, such power can also be exercised. Or the finding recorded is based on no evidence and or material evidence is ignored or judicial discretion is exercised arbitrarily or perversely. It is equally well settled that a revisional jurisdiction of High Court should not be exercised in a routine manner. The Honorable Apex Court, in the case of Chandra Babu versus State, reported in 2015 8 SCC 774, laid down a ratio that normally revisional jurisdiction should be exercised in a question of law. However, when factual appreciation is involved, then such exercise is to be carried out in a class of cases resulting in a perverse finding. It was further held that the power is required to be exercised so that justice is done and there is no abuse of power by the court. In the aforesaid backdrop, in the backdrop of aforesaid settled proposition of law and the evidence and the facts which are discernible from this court, this court is of the view that the learned trial courts below has not committed any patent error of jurisdiction or of law. The findings recorded by the court below are based on sound reasoning. Both the learned courts below has duly appreciated the evidence on record, and the conclusion arrived at on the basis of such appreciation of evidence cannot be termed as a decision which could not have been arrived at by a reasonable man on the basis of materials available on record. In view of the aforesaid, this court is not inclined to interfere with a determination made by the learned courts below in exercise of its revision power of in exercise of its revisional power. Full stop. However, this court cannot also be unmindful of the fact that when the impugned judgments were passed, admittedly, one of the son was around 18 years. The daughters were, another son was aged about 14 years, and other one was, a daughter was 12 years. From the death perspective, this matter is pending. No, full stop. The matter is pending since 2012, and therefore, from that perspective, the children would have become major by this time. And therefore, while parting with the record, it is provided that the petitioner shall be at liberty to approach the learned trial court below under section 127 CRPC, and on such application being filed, the learned trial court shall consider the same as per law. With the aforesaid, the criminal petition stands closed, dismissed. The LCR be returned back.
You see interim order.
Hmm?
Interim order passed earlier.
Interim order passed earlier stands vacated.
Obliged.
But all these orders will be by next Tuesday only. Uploaded, not things.
I'm appearing in item number 4.
Item number,
4.
you are the manager, you are
I am
the,
not the manager.
you
I
are-
am nurse. I'm the nurse of
you are the nurse, and who is for the bungalow? owner? Huh?
SK.
So both come and say that this is settled. We'll close it.
Better to dispose of both the case.
That is why.
That can be done.
See, not,
Because
apparently it seems
apparent-
both have filed some, there are some other issues, and apparently in the
He was the
affair it is
manager, she is the
exaggeration
nurse.
and all.
he rang her and he,
Uh,
spoke obscene language to
okay,
her, invited her to
And
his
despite that, she went to his bungalow and all.
Bangalore. And thereafter he lost the present case after 15 days. The
Ah.
present complaint in item number
So
4.
apparently it
Both
seems
the
that
cases
this,
may be disposed of. Both the
where is the other petition?
petition that are as some as they is there.
This is the difficulty, Mr.
In item 3, I am in item 4.
These two criminal petitions are taken up together for final disposal at the admission stage itself. Though, no, by these two petitions, both the petitioners are seeking quashment of two FIRs.
The one is complaint. Mine is complaint.
Is seeking quashment of two criminal prosecution, isn't it? Two criminal prosecution. 216 is your one is 216, is not it?
No, no, my against me is CR case number 24.
No,
of
no.
this.
Against you is CR case.
That is criminal petition number 410 of 12.
Criminal petition number 206/2013. No, little echo. Criminal petition 410 of 2012 is filed by one Rina Bala Nath.
And her husband.
Rina Bala Nath and her husband assailing for quashment of
Page 10 or something.
quashment of
Page 11.
the complaint proceeding registered as CR case number 24C/2012. C 2012 and order of cognizance dated 21/4/2012 passed by the learned judicial magistrate first class Bilasipara under section 500/506 IPC
By
in
34,
huh?
by 34.
by 34 500
500, 506 by 34 IPC.
plus 34 IPC in the aforesaid CR case 24C 2012. The accused in the aforesaid CR case is one Sri Manav Chakraborty, the petitioner in
Excuse me, his
you
complaint.
know who is accused in that is say in the criminal petition. One Manas Chakraborty is arrayed as accused, who is the petitioner in the other criminal petition, that is criminal petition number 216/2013. Criminal petition number 216 of 2013 is filed uh,
For quashing of FIR.
for quashing of FIR registered as
Support PS.
Sapor. Where is that?
Page 18 in my petition, it is the support PS case number 8/12
Mm.
under section 509, 507 IPC.
No.
In my petition.
Sapor PS case number 07/2012.
No, 8/12.
7 was filed by whom?
7 they have filed, but nobody has filed for quashing
No.
7.
Okay. Where is that? It's 8, na?
8. Support PS 8/12 under section 509.
Sapor PS case number 8/12 under section 509/507 IPC dated 9/1/2012. Full stop. After completion, the further challenge is an order dated 8/10/2012 passed by learned subjudicial judicial magistrate first class Bilasipara, whereby cognizance under section 509/507 of IPC was taken on the basis of the basis of the search sheet and GRCPR number 08/2012 arising out of Sapor PS case number 7 of 2012. Before proceeding further, let this court record the factual assertions made by both the petitioners in their respective complaint and FIR. First FIR, your complaint date, Mr. Talukdar?
Date is 9/1/2012.
This is
Annexure 3, page 17.
no, this is 9/1/2012
Is
is
the FIR filed by me. the
yeah,
wife.
that is Manav Chakraborty.
That is against one support.
No. 9/1/2012,
12.
one FIR was filed by,
Inabala Nath.
I'm telling you, by Manav.
That is another one. That
Why
that
not?
is
That-
not
that-
before your
that-
lordship.
Not before, but we'll have to record the facts. On 9/1/2012, petitioner Manav Chakraborty lodged an FIR before officer in charge Sapor police station against this lady, is not it?
Inabala.
Against petitioner Rina Bala, inter alia alleging that
Rinabala as well as her husband.
on 9/1/2012 said Rina Bala and her husband attacked him with sharp weapon
Not
in
directly attack, sent 35% with arms in their hand.
below noted accused person entered into my office of Bangla. No, it is this affair is different. That's why I'm recording. What is why should, because ultimately all things are different. Somebody says something, that's why we are causing it. That's why I'm recording it. Unless that wife no. Inter alia alleging that one Boloram Lohar, one Mitu Lohar, one Lua, Tarzan Lohar, and Alka Lohar entered into his office bungalow and attacked him with sharp weapon and injured him severely, etc. Said case was registered as Sapar PS case number 07 of 2012 under section 147/148/325/326/307/379 IPC. Such affair is not subject matter of either of the writ petitions, and there is nothing material is available on regards fate of such prosecution launched/initiated on the basis of such affair. On the okay, this is the first affair. Where is the 8?
8 is filed by me.
Ah.
That is
On the same date, that is on 9/12, 9/1/2012, the petitioner Rinabala lodged an affair against petitioner Manav Chakraborty before the officer in charge Sapor police station. Inter alia alleging that the accused Manavendra has been talking to her over telephone by using obscene languages, and thereafter
invited her to his bungalow.
invited her to his bungalow and enticed her to give a job and accordingly she lodged a complaint before the management of the tea estate where the aforesaid person was working. Full stop. Such affair was registered as Sapor PS case number 8 of 2012 under section 509/507 of IPC dated 9/1/2012, which is under challenge in criminal petition number 216/2013 preferred by accused Manavendra.
Manav Chakraborty.
Manav Chakraborty. Manav Chakraborty. Manav Chakraborty. Where is complaint?
Day after this, another affair was filed.
Ah.
On 25/1. Therefore, the complaint is filed, the present complaint,
Okay,
24/12.
okay. Then nine, it was filed by you, then 9, they have also filed.
Then on 25/1/12.
Then thereafter another affair was there.
Another complaint was filed by Manav Chakraborty against me and husband.
Okay, where is that?
That is annexure 1 in page 10. In my
Annexure
petition.
page 4. Thereafter, the Manav Chakraborty filed another CR case number 24/C/2012 before the learned subdivisional judicial magistrate Bilasi Para
On 25/1/12.
On 20,
5/1/12.
25/1/12 with an allegation that
Last para in the
Hmm.
fine, page 11, last para.
with an
At
allegation
present, the
that
accused person are conspiring to kill me.
with an allegation that the accused person, that is Rina Bala and her husband Kishori Mohan, are conspiring to kill him, and they have been accusing him falsely in front of the people in order to malign him in the society, and lodged a case with false allegation at Sapar police station. Full stop. Such, on the basis of such complaint, uh,
Cognizance of
the after filing of this complaint, informant Manav Chakraborty was examined under section 200 CRPC, and on the basis of the statement made and after perusal of the complaint, the learned subjudicial magistrate under its order dated 21/4/2012 took cognizance of the offences under section 500/506/34 IPC, which is under challenge in criminal petition number 401 of 2012. Heard Mr. D. Talukdar, learned counsel for the petitioner in criminal petition number 410 since 2012. Full stop. None appears for the petitioner in criminal petition number 216 of 2013. Full stop. 213. Mr. Talukdar, learned counsel for the petitioner in so 410, referring to the complaint has argued that the aforesaid CR case has been filed with a malicious intention to harass the petitioner, inasmuch as no case, inasmuch as if the complaint as well as the statement recorded under section 200 is taken at its face value and accepted to be correct, no case is made out. No case under section 500 or 506/34 is made out. Full stop. In fact, the lodging of FIR as well as CR case is the counterblast of the FIR lodged by the petitioner. Lodged by the petitioner. Full stop. This is your ground. Okay. This is your ground. Though none appears for the petitioner in criminal petition number 216, this court has perused the FIR as well as FIR under challenge as well as the grounds cited in the petition. It is the case of the petitioner that he lost the affair at the first point of time, and as a counterblast, the second affair, as a counterblast, the accused Rina Bala has lost the affair. Therefore, it is apparently an abuse of the process. According as pleaded in the revision petition, that on plain reading of affair as well as the search sheet, it will transpire that no ingredients of offense under section 509/507 of Indian IPC are made out against the accused petitioner. Full stop. I have considered the materials available on record. IPC condition. Materials available on record. The statements made in the connected revision petition and the litigational history as available on record. From the aforesaid, it is seen that the main issue that has arisen is out of an alleged attack on petitioner Sri Manav Chakraborty by some accused person. From the accused person. From the complaint, from the affair lost by Rina Bala against Manavendra, this court, from the Malkana, it is seen that if the allegations leveled by Rina Bala are accepted and treated to be correct, this court finds no material which even remotely suggests commission of any offense under section
509/507.
509/507. At the same time, the litigational history and filing of FIR against each other also shows that such affairs are being filed only to counter each other. Full stop. Now, coming to the CR case lost by Manavendra Chakraborty against Rina Bala, this court, even if accepts the allegations to be correct, the grievance suggests lodging of false FIR against Manavendra by Rina Bala, and if it is accepted in toto, including the statement recorded under section 200 CRPC, this court finds no material even to remotely suggest any offense under section 500/506/34 IPC. Full stop. This court also finds that the learned judicial magistrate has failed to exercise its power while taking cognizance inasmuch as the learned court ought to have applied its mind to the given facts and materials of the case. Full stop. In view of the aforesaid, this court is of the opinion that both these cases are fit case to exercise this court's power, revisional power, to interfere with the prosecution laws. Accordingly, so and so are set aside and lost.
Much.
উপর লিখে বড় ঠাকুরের নাম তুলে Okay, next case, next case. বারে বারে আমার miss yeah. Just look into it. Huh? Ready? Who is the petitioner in other case?
Mr.
You are,
N. Ahmed.
okay. N. Ahmed and you are for 5.
Munindra Haloi, I am for.
Munindra
accused
Hazarika.
Munindra.
Who are you?
I am an employee of my lord, a company named Ring Saria,
Ah,
who my lord takes the money from my lord bank and replenish the my lord the ATMs.
okay. What is the materials against you? Prosecution that on the basis of which?
This is that my lord, informant my lord.
Ah.
He has taken out some money from my lord the ATM in the Jalukbari.
Ah.
Here my lord, he has taken out.
There is some fake notes.
Yes, my lord.
Now, how you are roped in this case?
Because I carried the money, my lord.
And what are the materials on the basis of you have been charged?
That is the material, my lord.
Only that is the
Because
material.
only one fake currency note has come out from the ATM, my lord.
So
Charge
it is
is
that you
different.
have your consciousness is also important, no material.
No material, my lord. Absolutely no material.
Your lordship, my lord, this petition is against order of framing charge, my lord.
Huh?
So, my lord, your lordship may kindly peruse the evidence of my lord 161 statement of Syed Hibzur Rahman.
Who is Hibzur Rahman?
One of the
Who
accused, he is the branch manager, co-accused, my lord.
Branch
Is-
manager of the bank is accused.
Yes.
What he says?
He said that
But he
on
has
that
given
day,
the
my lord,
money, my lord.
and another, my lord, evidence of IDBI Bank assistant manager, two assistant manager, Lokhi Burman and Kumar Kaushik. And one is the evidence of my lord security guard who was appointed at that point of time for securing that, that ATM. And all named regarding the, my lord, lodging of the affair at that point of time, the complainant, along with that 225 notes, my lord, one was also fake note, my lord. At that point of time, he asked the security guard to give the phone number of the bank official while he not provided. Then he take the photograph through the, my lord, camera of the ATM and thereafter inform the police. And later on, my lord, during investigation, it comes to light that the present accused person, Munindra Alloy, all from all the statement of these IDBI bank manager, assistant manager, all stated that it is the person Munindra Alloy who collected the money from the bank and thereafter, my lord,
Deposited in
the ATM.
So it was his duty only to collect and deposit.
Deposit.
It's a clear case of discharge, isn't it?
Yes.
Tomorrow you may be also in difficult position. Ah. These cases ought to have been closed long back. Why since 2013 is pending?
It has not been listed, my lord. For hearing. He was there, my lord.
Out of 25 notes, only
Only
one
100 rupee note
100
is there, my lord.
remaining, sir.
I've got a decision of Allahabad High Court, my lord, what was saying.
Will not pass a lengthy judgment, shortcut. Munindra is the person who
Carried the money.
Carried the
in
money
my lord, that car.
and from the bank, and Hibzur Rahman is the branch manager
Branch manager of the IDBI.
of the
ID.
Bank, my lord.
IDBI bank.
This money has been taken.
Forget about Munindra may be suspected for some reason that he have changed a note and one note he will not necessarily, there is no complaint subsequent. Forget about that, but how the manager is,
Because he sent the money, my lord, he may also have put the money there.
either of them, until and unless there is allegation of conspiracy, collusion.
It's my duty, my lord. Then, my lord, this company ought to have been also put the, my lord,
But-
accused, my lord.
The third Mr. B. M. Chaudhuri, learned counsel for the petitioner, No, before that you write it down. These two criminal petitions filed under section 482 of the Code of Criminal Procedure 1973 is taken up for final decision today, together, full stop, together, for the reason that by these two petitions, two accused person has challenged an order dated 7/2/2013 passed by the learned Additional Session Judge number 4 FTC Kamrup Guwahati, whereby charges were framed against these two petitioner under section 489 within bracket B/34 IPC in session case number 205 within bracket K/2012. 2012. The brief facts of filing the present petitions are recorded herein below. One, Sandan Kumar Goswami, a student or what? Okay, one Sandan Kumar Goswami lodged an FIR before the officer in charge Jalukbari police station on 12/1/2010, inter alia alleging that when he went to IDBI Bank's ATM at Maligaon Sariali and withdrew cash amount of rupees 2,500 from the ATM, he received total 25 numbers of 100 rupee denomination note from the machine, and out of which he suspected 100 rupee note to be fake out of these 25 notes. Accordingly, he informed the guard on duty in the ATM about the same and asked the guard whether there is any contact number of the bank or complaint book available. However, when guard replied in negative, having no alternative, he displayed the note and the receipt in front of the camera fixed at the ATM machine, and accordingly, thereafter lodged the FIR for investigation. On the basis of the aforesaid investigation, on the basis of the aforesaid FIR, investigation was initiated. Jalukbari, no, on the basis of the aforesaid FIR, Jalukbari PS case number 27/2010 under section 489A/489B IPC was registered and investigation was initiated. After completion of the investigation, the present two petitioners were arrested as accused and were sent for trial. The petitioners asked before the learned trial court for discharge and contended that on the
Case was committed to the session.
okay, sorry. Thereafter, the case was search sheet was submitted. The committal court thereafter committed the case to the learned session judge, being a session tribal case. Full stop. The learned counsel, the petitioners asked for their discharge before the learned session judge, contending that the materials collected and statements recorded by the investigating officer during the course of the investigation, even is accepted to be correct, no materials under section 480
9B.
9B was made out. However, learned trial court, learned session judge under its impugn order dated Swenso declined to accept such contentions, and accordingly charges were framed against the present petitioners under section 489B IPC
34.
4
89.
under IPC/34. The similar argument has been advanced before this court that the learned session judge has committed serious error of law and fact and ignored the settled proposition of law, while framing charges, inasmuch as even if the prosecution materials are accepted to be correct, no case the petitioner could not have been charged under section 489B IPC. Full stop. IPC. What will be your argument, Mr. Bothakur? We must say that Mr. Bothakur
But,
fairly submits that there is no
but
material.
Otherwise, no material I cannot say, my lord, but.
You
my-
must say, because you are a public prosecutor.
Yes, my lord, but otherwise, my lord, because this is order is only against framing charge. So prima facie, because 3 witnesses named the present person, he is the person who collected the
Okay.
note.
Okay. On the other hand, Mr. Bothakur, learned additional public prosecutor, submits that learned session judge has rightly framed the charges inasmuch as at that stage a mini trial cannot be carried out and there are clinching materials which raises grave suspicion against the petitioners, both the petitioners being involved in committing the offense. Full stop. The principle of law so far framing of charges can be summarized as follows. Keep it. That is already I have dictated in some orders. Full stop. Now, on the basis of the aforesaid settled proposition of law, as well as material available law, let this court first examine the given facts of the present case. Full stop. From the statement of the informant recorded under section 161 CRPC, what is discernible is that the informant received a fake currency note of in denomination of rupees 100 while receiving 25 numbers of 100 rupees notes of 100 rupees denomination, and accordingly he lost the affair. You have who is Hibzur?
Who is the manager of the IDBI?
The accused said Hibzur Rahman's statement was also recorded by the investigating officer under section 161 CRPC. As per the aforesaid statement, the statement said Hibzur Rahman was the branch manager of IDBI Bank Panbazar branch. As per his statement, one entity names Brings Arja is entrusted with brimming cash from the branch for loading into the ATM of the bank at Maligaon Sariali. And such brings cash on behalf of another entity called Euronet, who works on behalf of the IDBI Bank. Okay. The the IO also recorded statement of one Hasnur Ali, repeat bank, huh? Then don't risk this. As per the statement of this Hibzur Rahman, the accused Munindra Haloi collected the cash on behalf of Brinks Arja on 9th of January. 9th of January. The IO also recorded statement of one Khasnur Ali under section 161, who is a driver by profession, and he was the driver of the vehicle which carried the sorry, not he. Muhammad Khusnur Ali, who was the driver of the informant, and what he stated is that he carried his owner to the ATM and his owner withdrew 2,500 rupees, and out of that a fake 100 rupees note was detected. Was detected. That was detected. Another person, namely Nirmal Dole, assistant manager of IDBI Bank, was examined under section 161 CRPC, and his statements were recorded by the IO. He stated before the IO that brings cash from the branch for loading into the ATM of the bank at Maligaon Sariali, and cash was collected for Maligaon ATM on 9 January by accused Munindra Haloi on behalf of Bank's area on 9th of January. Another person, namely Lakshmi Burman,
The security guard, my lord.
who was another statement of one Lakshmi Burman, and not another person, statement of one Lakshmi Burman, the security guard at the IDBI Bank's ATM, was also recorded by the IO and said, witness stated before the police that the informant withdrew the amount, and he was sitting outside, and this person was sitting outside the counter at that point of time, and he told him that there was one duplicate 100 rupees note, and also asked for telephone number, to which he replied that he did not know. One Raju Das, a businessman of the Maligaon locality, also stated that the informant stated that the 100 rupees note was seized by police in his presence, and he seized the seizure list. The statement of one Sri Kumar Kaushik, assistant manager of IDBI Bank, also discloses that the amount was collected by Brinks Arja on behalf of Euronet for loading in the ATM and Munindra Haloi collected the case on behalf of Brinks Arja. Any material as regards forensic? Where is that?
Positive.
Huh?
Positive.
Where is that? Uh, anything?
As per that report, my lord, it is a fake
Ah,
note.
hold on. The says note was also sent for forensic examination and report was given that the note is in fact a fake one. Currency note was in fact a fake one. Therefore, from the aforesaid materials, what is, if is accepted to be correct, what is discernible is that on, what is discernible is from that on 12/1/2010, the informant withdrew cash from the ATM of IDBI ATM from the IDBI bank's ATM at Maligaon Sariali, and out of 2,500 rupees note, he received 100 rupees note which is fake. And first of all, it is also prima facie appears that said cash was delivered in the ATM, transported, said cash was received by Munindra Haloi, accused Munindra Haloi from Syed Hifazur Rahman, Munindra Haloi, received by Munindra Haloi, who is an representative of Brinks Arya. Full stop. Brinks Arya is entrusted with the responsibility of transporting and replenishing ATM machines on behalf of one entity called Euronet, which is having a contract with the IDBI Bank. It is also prima facie seen that Syed Hifzur Rahman, the accused, was a branch manager at the relevant point of time who had handed over the cash to Munindra Haloi for replenishing the same in the ATM machine. Admittedly, neither any competent authority of Brinks area or any competent authority of Euronet has been arraigned as accused, nor any of their representative has been examined as witnesses during witnesses. First of the other witnesses who are bank official also ascertain that money was handed over to Munindra Haloi from the bank as a representative of Brinks Arja, and that Brinks Arja works on behalf of Euronet, with whom the bank is having a contract for transporting and replenishing the cash in ATM. Section 498, 489B Mr. Chaudhary, you wanted to give us a elaborate, no? Section 498,
489.
sorry, 489B. Of IPC makes, makes selling, buying, receiving, using as genuine or otherwise trafficking in counterfeit currency notes culpable. Full stop. Therefore, there are separate and distinct act or illegal omissions independently constitute a crime. In the case in hand, if we go by the materials collected by the investigating authority, it is seen that the often seen that the allegation against Syed Hibsur Rahman is not clear in as much as the material suggests that he handed over the cash as a manager of the bank. Manager of the bank. There is nothing material on the record to suggest any mens rea on the part of this accused person. Thus, even if he is having possession, okay, full stop. It is equally well settled that no, in the case in hand, here the material collected by the prosecution merely suggests possession of such currency note by both the accused Munindra Haloi and Syed Hibzur Rahman. And it is an admitted position that they have acted in discharge of their duty, and there is no material to suggest that such possession was a conscious possession or they were involved in selling, buying, receiving, using a genuine or otherwise genuine or trafficking counterfeit currency note. Though it is seen from the chain that the LS currency note was found in the ATM that and that said note was transported by the accused Munindra on being handed over by accused Syed Hibzur Rahman. There is no whisper or any suspicion to suggest as regards their culpability and consciousness and their involvement in the present case. Full stop. Therefore, full stop. This court cannot be unmindful of the material so far collected by the IO that there is no material to suggest that appellant that the petitioners had committed any offense under section so and so so and so. The Honorable Apex Court okay, in view of the aforesaid, I'll elaborate later. Some judgments I have not been finding it out. Where is it?
Umasankar versus State of, there are 10, my lord. Umasankar versus State of Chhattisgarh, the Supreme Court held.
Umasankar versus Chhattisgarh. Na? That judgment I was fighting. Umasankar versus
State of Chhattisgarh,
State of Chhattisgarh.
Supreme Court held that mens rea or offense under section.
Any citation of this case?
That citation, my lord, I could
That
not
also that is Umasankar versus State of Chhattisgarh.
find.
Huh? Okay, I'll find it out. Come on. It is in the case of Umasankar versus State of Chhattisgarh, the Honorable Apex Court laid down that mens rea of an offense under section 489B and 489C is knowing or having reason to believe the currency notes or the bank notes are forged or counterfeit. It is true that this court cannot determine the mens rea at the stage of framing of charge. However, there must be some material even remotely suggesting such mens rea on the part of the persons, inasmuch as in the given facts of the present case, there is no dispute that accused Hibzur Rahman was the branch manager and Munindra Haloi was an authorized person to transport the alleged to transfer the notes to the ATM. Therefore, in the considered opinion of this case, no case of selling, buying, or receiving any fake currency note is made out from the materials available on record. Accordingly, in the considered opinion of this court, the learned trial court below has failed to appreciate this aspect of the matter and mechanically frame the charges against the accused. Accordingly, the present petition stands allowed by setting aside and quashing so and so so and so. Accordingly, the accused petitioners are discharged from the charges under so and so so and so. We'll elaborate. You will get this order maybe by next Thursday.
This is 2001 supplementary 3.
This,
Yes.
2001
Supplementary 3,
Supp-
SCR 646.
SCR 646. That's why it is not available. 646, huh? Dispose of. Retry. Common judgment. Huh? Break. I should take break. Yes, what is item number 7?
Must-
Yes, Mr. Agarwal, we'll proceed. It is ready. Everybody is ready. No, we'll come back. That's why I'm asking. Ready?
Yes.
What are the issue here? Quashing.
Basically, the quashing malad, there is a will.
Oh,
Right.
that case.
Nothing is there.
Nothing is there.
Nothing is there. Malad, your lordship, and the PDF.
Apparently, what has been written is a fantastic drafting for a civil suit.
Yes. My lord, main thing is that your lordship.
No,
will
I
consider-
understand. Just we'll come back.
Yes, yes.
We have not taken any.
Yes,
Don't
yes.
don't think that I have taken any view.
Mm.
We'll hear you.
Yes, yes,
We'll
yes.
hear you
Yes,
patiently.
yes.
Any suit file in the meantime?
No, no. One foot is filed by us, my lord. We have
You-
already filed because of some, my lord, trying to dispose it and all
But
that.
the will you have will is a part of this. Your basic.
No, no, basic grievance is that secreting of that will, particular will, and I was deprived of the legitimate dues.
But
and in
you
the
are
process-
having a copy of the will.
No, I did not have. I
But you have
later on,
any-
later on I came to know.
No, but
When
a copy
when
of the will is a part of your complaint.
petitioner, yes, that
Then-
came to my knowledge later on, at the very later stage. And thing is that was secreted by the petitioner.
What is the offense secreting?
Secret for 477, but that was not, cognizance was not taken
Then
under
wha-
that section.
then-
The thing is that, my lord, cognizance was.
Okay, we'll
taken-
come back. We'll
Yes,
come
yes,
back.
yes.
We'll come. We'll hear you.
Oh, yes.
We'll not hear you. Then we'll come back to you. Then this is then item 8, na? Okay. Okay, we'll come back. Yes.
Lordship may come to page number 26.
We
Page
could
26.
understand, see, we presume his argument is that no case is made out. This is a civil dispute. This is your argument.
That is a basic, my lord, and second aspect of the matter, my lord, the case was filed by a power of attorney holder.
Hmm.
But he cannot give his statement, your lordship, nothing has been said. These two statements recorded,
Hmm.
one of the aunt and another is of the power of attorney holder who filed this suit.
Okay, fine.
Not maintained.
Okay.
And my lord, it's a pure and civil suit, if any at
Hmm.
all,
Hmm.
dispute with regard to land,
Hmm.
or there is nothing. And my lord, so far, my lord, 477 argument what he is saying, my lord, it was not secret, it was when the will could be, my lord, we got the will.
Hmm.
It was divulged to the one of the, my lord, uncle who was residing at USA. And then from them, it was, he also came to know about that.
Yes, let us see.
Yes, lordship may come to page 26,
Page twen-
paragraph
Page
11.
26.
26 of the criminal petition.
26 of the criminal petition.
Yes.
Yes. Yes, page 26.
This is the relevant portion.
May I just,
Aye.
I'm sorry. Accused number 1 has already died, father,
Mm.
against whom the entire allegations are basically there.
Mm.
That we have already informed, I think there is an order to that effect also.
Okay.
Sorry, I'm sorry for interrupting.
Your lordship will consider everything on merit. There's nothing. I'll submit before your lordship that yes, this is my case.
Hmm.
And thereafter your
No, no,
lordship will
no,
consider my case. Yes,
no. We are here to
yes,
listen you
yes,
because our thinking are not absolute.
yes.
Okay. So we understand. Suppose I have taken a view from reading only the complaint. You may
Yes.
change my view. No problem on that. That's why we are hearing you.
Yes, yes.
Yes, proceed.
And without
Don't take
hearing
that.
both
I
the
will.
parties-
I will come with it's a made up mind. No,
It's
I'm
nothing like-
always open,
it's
I'm always
nothing
open,
like
yes.
that. Yes, yes.
and I'm ready to accept my mistake. No
Yes.
problem on that.
My lord, this is the relevant portion,
Hmm.
relevant paragraph of my complaint petition. Paragraph 11.
Hmm.
I'm reading out the contents. That the aforesaid will of late Dulabhananda Chaudhary was made long back in the year 1987 on 14/6/1987 in presence of 3 attesting witnesses named therein,
Hmm.
which was to be executed immediately after the death of the testator, Sri
Hmm.
Dulabhananda Chaudhary, by producing the same before the competent court,
Hmm.
along with the necessary application, petition, etc. for grant of the probate of the accused, probate by the accused number 1, Paramananda Chaudhary. However, accused number one, instead of producing before the court, has been concealing the will from the rest of the family members in total disregards of the last intention of the testator.
Hmm.
The accused number one, by his above act, committed the crime offense described under the above penal sections.
Which above penal section?
Section 4,
Where do we get above is, where do we above section?
above sections means the sections under which this complaint petition was filed.
Let us see what are the.
403, 404,
Okay,
406,
okay, okay, fine.
and 420, 448, 34.
Mm.
These are the provisions.
Okay,
But so far, section 47-7 it is missing because of some mistake on our part. It could not be, I mean, incorporated in this petition. But prima facie, if we look at the facts disclosed in the complaint petition, that goes to constitute an offense under section
cognizance was taken under what offense?
406 only.
Then you are not aggrieved by that.
We are, even though we are aggrieved, we did not prefer any petition before this honorable court. So that can be presumed that we are not aggrieved.
Not aggrieved.
And prima facie, it appears that, Your Honor,
So 477 is gone now.
470 is that can be sought, or that can be, even there is provision in the CRPC for amending the charge. Even in case of complaint case, there are provisions in the CRPC
Okay,
for amending the charge.
Okay.
You can make appropriate application before the trial court for amending the charge.
okay.
So, my lord, total disregard of the intention of the testator, the accused number one, by his above act, committed the crime offense described under the above penal section. Moreover, the movable properties mentioned above, which are believed to be with the accused person, might have been misappropriated by the accused person without the consent and knowledge of the complainant and other legal years of late Durlabhananda Chaudhary. The complainant is also unaware of the present status of the immovable properties other than the ancestor house located in Dehabari. Under the circumstances, the accused persons are also accountable to the rest of the family members, more particularly to the complainant, as to what they have done with the properties without the consent and knowledge of the other legal heirs.
Mm.
So this particular paragraph says that there was a will that was left by the testator. And when there is a testamentary disposition left by any deceased person, that should be given full respect and honor by everyone, because that he has already gone.
Mm.
He is no more in this
Mm.
earth.
Mm.
That was his last vision. That was the last vision intention of the last testator. So anything done contrary to that intention amounts to crime
Under what provision?
under all these provisions.
How you
406
show us?
But it was entrusted, the document was entrusted to him as
Ah.
an executor.
Uh,
He had the possession of the instrument.
how he has used it to himself, how he has tell us.
He did not approach the appropriate court for getting the
There is a
permit.
provision, if the executor did not approach, the
I am-
others can approach.
My lord, other cannot approach.
Why
because
not?
He was the executor.
What is
Because we did not-
suppose there is executor is not put the probate will to the probate, what is the remedy?
Remedy, the letter of administration,
Then,
we can go. But thing is that we did not have the original will with us. We have to produce
so
the original will.
therefore there is a crime.
Yes, that is
Okay,
crime.
okay.
My lord, Lordship may kindly scrutinize the thing in proper perspective.
Huh.
Means
That
thing
is what we are
that-
trying.
Yeah, that is what.
That is
The
what we are trying.
original which is lying with the gentleman,
Mm.
and that particular gentleman was not using that will.
Mm.
He kept that particular instrument in his possession
Mm.
without the knowledge of the others.
Mm.
And later, at the very later stage, the point of time, he communicated to the other brothers by giving the Xerox copies only.
Mm.
On the basis of Xerox copies,
Mm.
probate cannot be applied. Original will has to be produced before the court.
Mm.
And this was the duty given by the testator himself.
Mm.
In the will itself, it was written that yes, petitioner number one will go
Mm.
and get this, will probate it.
Mm.
That has been disregarded by the petitioner number one. Then again, that particular will came into light after a long period, like after a long gap,
Mm.
and that too one Xerox copy was given.
Mm.
And then my client, he came to know about the existence of this will, and thereafter he filed this petition. And this is the reason we annex this will, copy of the will with our complaint petition, stating that yes, the will was there, but that was concealed. Now concealing itself is a very serious crime
Mm.
under IPC.
Mm.
But somehow that particular section was missing.
Let
I'm
us
not
see,
on that-
let us
I'm-
see what 477 says. IPC.
That is not in the charge.
Okay, no,
Again,
let us, we
yes,
accept
let
your
us- let us-
argument
let us-
that can
let us
be,
examine
that
this.
can very well be framed. Let us
Yes,
see prima facie
yes,
what is
yes,
the
yes, yes, yes,
477.
477
Mm.
of IPC. Fraudulent cancellation, destruction, etc. of will, authority to adopt or valuable security. Whoever fraudulently or dishonestly or with intent to cause damage or injury to the public or to any person cancels, destroys or defaces or attempt to cancel, destroy or deface or secretes or attempts to secrete any document which is or purpose to be a will
Hmm.
or an authority to adopt a son or any valuable security
Mm,
or commits mischief in respect of such document
mm,
shall be punishable with imprisonment for life
mm.
or with imprisonment for either description for a term which may extend to 7 years and shall also be liable to fine. Now, if your lordship allows me to just elaborately explain this particular provision,
Mm.
your lordship may kindly take the relevant
Now,
portion
this offense was committed by whom?
by the accused number 1.
Now, accused number 1 is no more.
Other parties are also engaged.
Now, let us see what are the attribute to the other accused. Forget about now the accused.
Other
number one.
activities.
Yes.
NOC
So far
was taken,
relating to
NOC
so far relating to concealing.
No, so it was concealed. First of all, the
No,
provision
no, we
says
accept it. We accept it. For the time being, accused number 1 committed an offense under 477.
477.
Let us accept for the
let
time
us,
being.
let us
Now,
accept.
it,
And
this,
thereafter,
this cannot be proceeded against him as on date, against this accused.
Your Honor, my lord, one particular.
No, no, just answer me. No, if you say no, this can,
He is already dead. He
so
cannot be
no
prosecuted.
criminal prosecution against him.
But so
Okay, fine. Now let us therefore see what are the allegation of 477 or other offense against the other accused.
yes.
Forget about now accused number 1,
Mm.
because
Uh,
we will not waste
the-
our time looking into the allegations against a dead person,
Mm.
because you cannot prosecute him. Now let us see the other. Who are the other accused?
Other accused his sons.
Okay, what are allegations against them?
It is written in the provision itself that commit mischief in respect of the particular property, particular instrument.
Hmm.
Okay.
Hmm.
The thing is that in the given case, in our case, what happened? The immovable property, which is a subject matter of the will, was given on mortgage to financial company
Hmm.
by one of the sons
Hmm.
for constructing, raising a house
Hmm.
on that particular immovable property.
Whereas the allegation against them, let us see from the complaint and
Yes.
200. That's all. Because see, Mr. Counsel, we will have to decide a matter within the prescribed limitation, is not
Yes,
it?
sir.
We cannot go here for a roving and fishing inquiry. We'll have to see whether on the basis of material available on record, at this stage, the statements in complaint and the record under section 200 will accept everything to be correct. We are not saying that you are right or he is right.
Yes,
We are accepting everything to be correct.
yes.
Okay, now on that basis, let us understand what are, as per this complaint, whether those statements which implicates the other accused person of committing some offenses.
Paragraph number 12. My lord,
Okay,
of
let
my-
us see. Paragraph
of my
number
petition.
12.
Paragraph number 12.
Okay. Hmm.
That the accused number 3, who is a self-employed person in connivance with the accused number 1, has been using the aforesaid will of last Durlabhananda Chaudhary for his advantage from time to time.
Hmm.
He was also reportedly used the aforesaid will for availing a housing loan for constructing a house on the aforesaid Rehabari land by misrepresentation that the property belongs to his father in terms of the said will. without informing the other co-owners of the scheduled property, and while doing so, the accused number 3 did not obtain any NOC from the other co-owners,
Mm.
including the complainant.
Mm.
So Lordship, thing is that if facts disclosed in my complaint petition prima facie shows,
Mm.
prima facie amounts to any doubt, any suspicion in the mind of the trial judge,
Mm.
then he can very well, on the basis of the suspicion only, he cannot proceed. What he will do, the learned judge, learned magistrate, he will examine the accused person on oath.
Hmm.
And that was also done. Your Lordship may kindly come to that. It is page
Accused person or note?
complainant. I'm sorry.
That
I'm
is
sorry.
200, that is what I'm-
200, what did he say?
No, let us first see the complaint because 200 statement is taken
Corroboration.
on for the purpose that the complaint is filed and this is supported by this under section 200. It is a
Corroboration,
part
yes.
of the inquiry.
Yes, yes, yes.
Yes, now before we
So-
go to that, let
And-
us see what are the cases made out. So this is again accused number 3 and
Then accused number 3, that the accused number 2, 13,
Hmm.
has been carrying out the above illegal and unauthorized activities in active connivance of the accused number 1 and 3. It is pertinent to mention herein that the accused number 2, who is a practicing lawyer, has been passively participating in the above illegal activities of the accused number 1 and 3, despite having full knowledge that such activities are illegal and may render him liable to be prosecuted in the court of law. Thus, the accused person above named, in furtherance of their criminal conspiracy, committed the offense punishable under section so and so, so and so, so and so. So this is how I explained that yes, they are very much party. They were party in the crime, committing the crime. Whatever crime has been committed. Thing is that something was entrusted. Durlabha Nanda Chaudhary, he died. And he had full trust and faith upon petitioner number 1. And this is the reason he made a will and entrusted that will to that gentleman, that you get it probated and thereafter get the entire property distributed among the legal heirs. That was the degree of trust, shown by the deceased person. Thereafter, that was given to him. And other beneficiaries, they were unaware at that point of time. And this particular fact got unearthed, means later came to light when he communicated one copy to one of his brothers who resides outside India. Then
where is that statement?
Right.
Right.
Sorry, I'm sorry, 9.
paragraph 9.
8 and 9
Yes,
both.
yes, yes.
Okay.
8 and 9.
The above fact was informed to the complainant by his paternal uncle Sri Utshavananda Chaudhary, based in information given to him by the accused number 2 Sri Osim Chaudhary by his letter dated so and so, sent to Sri Utshavananda Chaudhary through email. The copy of the letter along with the will was also supplied to the complainant by Sri Utshavananda Chaudhary.
Hmm.
So when he came to know in the year 2010, and prior to that,
Hmm.
a
So
considerably
as
long.
per your statement, there is no intention to conceal.
Then why it was, lying
You
in
do
his
not know.
person?
This is your case. We cannot go who is wrong, who is right.
Ah.
We'll have to take note of your complaint as well as your 200 statement.
Maybe,
Even we are not accepting any documents or defense case of them. We are not accepting them. We are accepting only whatever you have stated in the complaint and 200.
my lord,
That's all.
will is such a thing.
Mm.
Will is the testator dies.
Mm.
He leaves one will
Mm.
with the expectation that yes, a true and faithful action will be shown by the testator, whoever, by the executor, whoever is named there. And this is the reason petitioner number 1 was named as executor in this particular will. And he did not take any action. And he, during this period, 1987
Mm.
till 2010,
Mm.
he has been in possession of the will.
Mm.
He did not show this will to anyone. And he has been reaping the benefit after the property, ancestral property, all by himself and by his sons, 2 sons. This is my case. This is my case. And that is
This
too
is
by
this is a base case for partition.
that's a different issue. I have many, recourses, but so far my recourses for
So therefore, whether we'll also examine whether a criminal tone is given to a
Yes.
civil dispute.
my
That is
submission,
one of
my
the-
humble submission before your lordship is that I may have a civil grievance.
Mm.
I am not into debt.
Mm.
Civil grievance, I'll take necessary action. So for criminality and the crime committed against me, I am with those, facts and case, I am before your lordship,
Yes.
that this is how this crime was committed against me.
Mm.
Because I was too young, I was of very tender age, I was thrown out of the house, and this particular instrument where all the benefits were reserved in my favor was concealed. It was kept in dark till 2010. This is as per section 477 of IPC. This is an offense.
Mm.
And the punishment prescribed, your lordship may kindly take note of the punishment prescribed.
Mm.
The life imprisonment
Mm.
and 7 years. It's a very grave crime. A person who was entrusted. So 406 is an appropriate case. Even all the sections which were, sought to be, applied on the accused persons, he ought to have been charged under all these sections, including 477, my lord. And moreover, one more thing,
Mm.
if a trial court, assuming his jurisdiction,
Mm.
a complaint has come, and he has examined, the trial judge has examined the facts of the case, examined the witnesses also. Thereafter, he has come to a reasonable finding that yes, there is a prima facie case made out under section so and so, so and so.
Mm.
And jurisdiction is also vested with him.
Mm.
Well power. And for that conclusive evidence is not necessary, my lord.
Mm.
Only mere suspicion is enough to, go against a person, provided that his suspicion is corroborated with the evidence. Evidence of record of the witnesses examined under section 202 and 200
Mm.
of the complainant.
Mm.
And that those parameters has been, fulfilled
Mm.
by the trial court. Trial court did not issue process. And moreover, one more important aspect of the case is that the trial court only issued process.
Mm.
And thereafter, the accused person, had they been aggrieved at all by the issuance of process, they could have, entered their appearance before the trial court and could have taken steps.
Mm.
There are provisions made in the CRPC, my lord. There are provisions made in the CRPC for getting discharge of an accused person. If he is wrongly implicated in a case, he can very well file an application before the trial court for getting himself discharged by the court. And this trial court would have given that opportunity to him. But instead of doing that, what he has done, he has approached this honorable court at the very threshold.
Mm.
He simply received the summons and he has rushed to this honorable court for quashing of the proceeding. So what is the use of giving vesting of power with the trial court if this sort of quashment takes place? So lordship may kindly look into this aspect of the matter. He acted judiciously. He acted legally. The trial judge.
Mm.
He examined the complainant under section 200, witnesses present, perused the records, including the notice which was served upon them, including the reply given by them. And your lordship will be taken by surprise what reply was given by them. They referred to some provisions which are not applicable in the instant case at all. They referred to section page 76 of the criminal petition.
Mm.
On discovery of the execution of the adversary, my client consulted. This is the reply given by the advocate for the accused person.
Where do you get that?
Because this is at page 76 of the criminal petition. On discovery of the execution of the aforesaid will, my client consulted late Bhola Ram Das, retired district and session judge during his lifetime, and also took legal advice from lawyer in view of the provision of section 213 read with section 57A subsection A and subsection B of the Indian Succession Act 1927, my client was advised that he is not required to take any probate of the will to establish his right as an executor. Now, your lordship may kindly refer to the provisions which is laid down in the Indian Succession Act. These are not applicable, not at all applicable in the instant case.
Page.
Page 76 of the criminal petition.
What is this?
Yes, they had to give one reply. First of all, they took 3 months time. They first of all, on receipt of the notice given by us.
This
they
was
took the-
replied to you when?
This was replied to me on 5th of October 2013.
When you filed the complaint?
Prior to that, he gave me one more reply.
When?
That was on.
When?
That was on.
Yeah, when it's equal.
That
was
is
the-
here. There where I mean,
Where? Page.
this is available.
This is 5/10/2013.
Yes.
This is an admitted document and
No. This is not page 66. Prior to
page
that,
68.
yes,
Page
yes.
68, one of the reply
Mm.
on behalf of the accused. Is not it?
My lord, this is the same. It is dated 5/10.
It is in
The
5.
prior to that, one more.
Where do we find that?
It is here only. Let me.
Page.
Page. No, it is not here. In fact, yes, it is here at page 56 of the criminal
56.
petition. On receipt of the notice, this notice was served upon him, and this is the response given to him, given to us.
Just a minute. Just let me flag mark it.
And prior to that, at page 50, the
Okay,
notice
this
served upon
is
him.
seeking time that we will want to.
Seeking time.
And where is your notice?
My notice is at page 50. This is self-explanatory. It will speak the entire case. Very important.
This is very important.
Important so
This
far.
document is very important for this case.
Because they were given full
Ha.
information.
These 3 documents are very important for determination of this case. Matter ends dear.
Two also, my lord, will can see 200.
Forget about 202.
My lord,
202 is
They
nothing.
short time.
They say that these are information grandfather so and so is having a will, so on and so forth. Please, these are the things.
Page 59
Page 59.
and 62. My lord, I have given the English translation.
No.
The vernacular version is also there.
Lordship is referring to the notice portion probably.
Yes.
The notice, yes, of course, notice was served upon them. And in the notice, the intention is also very much clear. The notice, the operative portion, the last portion of the notice. You are therefore called upon hereby to produce the aforesaid will before the competent court, that the court of the district and session judge Kamrup Guwahati for grant of probate, intimating me and my client in writing within a period of 15 days from the date of receipt of the notice, failing which I have definite instruction from my client to initiate appropriate action against the competent court as per provisions of law applicable in this matter. In that event, you shall further be liable for the cost and consequences. Further, you are take further notice that on your failure to produce the aforesaid will before the competent court within the period of 15 days, my client has instruction to take all necessary steps to cause the partition of the appropriate as per provisions of law for instituting suit proceedings appropriate forum. And the case of the complainant is that the will was lying in his possession.
Yes.
Oh, so far civil consequence is there,
Mm.
we are not denying that. We have that right. That may be time barred because of operation of law or some other thing. But thing is that so far criminal aspect is concerned, whether the parties, whether the accused person, they committed crime by resorting to this sort of activities for their benefit or not. This is the area to be, looked into by this honorable court. Because whether the element of crime is there, present in the instant case, in the case of concealment of the will or not. Element of crime, like criminal intention, mens rea, all these aspects, and these very aspects were examined in the inquiry held by the magistrate, trial magistrate. Trial magistrate, after examining the complainant under section 200 and the witness present, came to the conclusion, and lordship can we come to the impugn order which has been challenged. Impugn order at page 64.
Please read it.
Complaint is present. The case is fixed for necessary order.
Mm.
Peruse the complaint petition and statement under section 200 and 202. On going to the same, it appears to me that there is sufficient ground for proceeding under section 406, 34 IPC against the accused person as named in the complaint petition to proceed with the case. Accordingly, cognizance is taken. Issue summon. So at this stage, this is just the threshold that whatever complaint petition was filed, that was entertained. It was registered, it was laid before the trial judge, trial magistrate, and it was entertained. Okay, I'm taking your cognizance of whatever you are under this particular section. Let us issue process.
No, we know
Because
that.
he
No,
had
you need
reason.
not. You need not say we know that.
He had reason,
Yes.
reason to hear them,
Mm.
and thereafter provisions are there. Because
We
explain-
understand that. You show from your petition as well as from 200, where is the offense under 406?
It was entrusted it was entrusted to him, 406. Let us read. Criminal breach of trust.
Mm.
Okay, criminal breach of trust is defined under section 405. Whoever being in any matter entrusted with property
Mm.
or with any dominion of her property,
Mm.
dishonestly misappropriates or convert to his own use
Mm.
that property, or dishonestly uses or disposes of that property in violation of any direction of this law prescribing the mode in which such trust to be discharged,
Mm.
or of any legal contract,
Mm.
express or implied, which he has made touching the discharge of such trust, or willfully suffers from any other person so to do, commits the breach of trust.
Which property was entrusted to
The
him?
entire immovable property was entrusted to him. The will is a very part of the instrument.
Will is not entrustment of property. Will is a distribution of property. Suppose a person dies today, okay? His eldest son is residing in his 10-storied building, okay? The deceased was collecting the rent. Okay, fine. He dies and the eldest son was there possessing in his things. Will it mean an entrustment?
It
And
is
he
a-
is having 3 sons. If everybody is sleeping without claiming for partition and
No
claim,
one was sleeping. They were totally unaware.
What
And
unaware?
they will
Are you
take
not
this-
unaware that my father or
One of the-
grandfather died? He had left this property.
My-
My parents there.
one of the brothers, he resides outside India, and he was communicated in the year 2010.
Okay.
And here is the entrustment of property or with any dominion over property, dishonestly misappropriates. In the misappropriation case is also present. Entrustment is also present.
What he has misappropriated? Tell us. Where is your statement that he has misappropriated this property was entrusted him, except saying that will has been withdrawn, secrets concealed? Where is the entrust? It will be very difficult to, if we hold that on the date of a father, the son who was possessing the property is being entrusted with the property. Therefore, it is his responsibility to invite everybody. In somebody waives their right, will not coming for, forget about the will. You are otherwise entitled for a share of this property, is not it?
But as
Will
soon
it
as
mean that your property has also been entrusted? Moment he dies, it is one share is yours. And nobody has entrusted him with that property.
Understood, my lord. So this aspect is covered. But only thing is that, yes, we only thought that we are rightful owners. We'll inherit to the share of our properties. But in the year 2010, he came out with the instrument, will. And till that point of time, he has been misusing that will. He has been enjoying the property which was the subject matter of the will. This is the case.
Will say this is an, I'm telling you what we'll say. This is an absurd allegation. On the basis of an will, a property is not entrusted until and unless it is probated. So
Yes.
non-probation is to your advantage.
Yes. In that case,
Number one. Number two, a property cannot be, it is an absurd allegation. A property cannot be made grace on the basis of an will which is not probated. Until and unless a will is probated, it is having no value. It's a piece of paper only. That's all. So your allegation is absurd that he is using this property, misappropriating his property on the basis of an will.
what about
That's all.
What about the concealing of the will till
Where is
2010?
where is your, you have not prayed for giving any things, application or anything in the record. Court has not taken any cognizance. Why should we, you are not aggrieved that he has wrongly not taken.
I am aggrieved by the I'm not, I'm at this point of time, since this particular discussion is taking place and we are confining to this area, the 477 is 477 is also covered. This is the reason I'm submitting in respect of that particular.
Will taste this order of the magistrate
Ah,
and the on the basis of, and the application and the 200 statement. That's all.
yes. So on my respectful submission before your lordship is that if we take all these parameters together, like my giving notice, it starts from my giving notice to the other side and their reply to me.
Then to it goes
Then
every,
civil part is there.
then door is closed for 477 also. There is no
Let me take
consignment.
you to one
He said,
thing.
yes, I have all, you, in your own, you said that he has informed it to my uncle. And then I demanded him, then he said, okay, come and you probate it, you take the will and probate. That is statement is there in the second reply.
The original was given, original was kept by him.
So he said,
and-
please come and take this and get it probated. I am not inclined, I am
No,
not
that was not the
interested.
reply. My lord, that was
Kindly
not the
come
reply.
kindly come.
Let us see, examine the reply given by him.
Ah.
Oh.
My is lying intact. That is then let's settle with the law. My client is not required to obtain the probate of the will dated so. The immovable property bequeathed by late Johanna Chaudhary in his will dated so is light intact. My client is being executor will call upon you client to take charge of the opposite bequeathed property from my client and take necessary steps to get the records corrected in revenue records and all the other relevant records, including municipal records, on the strength of the will dated so within a reasonable period of time from the date of receipt. So he is willing for the will. Everything is intact. Where is the offense?
Is it the process? No, this
We do
was
not
the-
know where is
no,
the your allegation is that he has concealed.
my
He
lord,
has
this-
misappropriated.
My lord,
On your demand, he files an reply. This you have admitted. What more is
my
required?
lord, this repaired.
We have given you enough hearing.
Yes.
Dismissed.
Allow.
Dismiss means allowed,
Uh,
allowed, sorry, allowed,
it is allowed.
allowed.
Must oblige, your lordship has afforded much time.
Yes, yes.
And I have also got opportunity to explain
Yes.
ultimate decision of your lord.
Okay, let us do one thing. Hearing concluded, judgment reserved, because it will take 5-6 days to upload. It looks bad. Hearing concluded, judgment reserved. Both IA.
Oblige.
Enough.
Uh,
He had a good case for a civil suit,
civil suit, that, yes. You,
but you said that is time barred, but
No.
that is time barred, maybe time barred because of wrong advice. You are litigating in wrong place. We have a full sympathy for him, but this is not the place to do things.
it may not be time, but because.
It's a,
it
we
is
are not,
up to-
we are
yes,
here,
yes, yes.
we are not here.
And there are provisions for enlarging time even under statute.
That's all. And yes, what are the other methods? Next is? Here,
So we'll sell.
yes, what is this hearing method?
Item number 8 is mine.
Item number?
Hearing
Eight.
method.
PC Act, 1 year. Yes. If his wife is having a job.
Well.
Huh?
My lord, but that was not proved before the court, my lord.
Who will prove it?
My lord, they can appear before the court and DW, they may.
No, not DW. Prosecution has himself has admitted that his wife is a government servant.
Government servant, but she.
If he is a government servant, admittedly government servant, then admitted you yourself has admitted that it was constructed by loan. While preparing the inventory, that income and asset, was it not your responsibility to incorporate that? Then whole foundation is gone.
But from the evidence and other final report.
No, it is a prosecution case that this man is having income of so and so, so on and so forth, and his proper assets are this and this, which includes the house. Okay. So your whole projection is that he has earned this much and acquired the house of 11 lakh something, this house. In the evidence itself, the prosecution says that yes, his wife is a school teacher. Yes, there was a loan in this house. And if that be so, it ought to have been incorporated in your inventory, that this is income, that in your report. If this is not done, if you admit that it is not his sole income, his wife is also having income and that is not incorporated in your allegation, then matter falls there. Second part is, admittedly house was constructed in the year 91, something like that. 83. And it was inspected in 1986, 96 and 97 on the basis of the PWD rate of 96. That is also admitted. So whole calculation is wrong. On that ground, there is a doubt is created. So benefit is doubt should go to the prepare on that. Today?
Then I will have to go through it.
I go through. So I'm saying this is the evidence.
That apart, my lord, and an income of rupees 2,23,000, agricultural income was also not included.
That even if we do not go to that. The foundation of disproportionate assets was a doubt was created through the witnesses, forget about defense, through the witnesses of the prosecution itself. Then if prosecution had been firm, then of course, in such cases, PCX honors will shift to him to show that no, this is my wife's this and that. The prosecution witness admitted that.
In the IO also in his.
Yes, IO, forget about others. Okay, when? Tell us when.
Next week, my lord, any other day.
Next week when? Yes, give a date next week.
Any day, my lord, except 19, my lord. Any day.
19 is not possible. Mostly will give a date. 21. 21st of November. Huh? Yes, 21st of November.
Or first week of December, then maybe.
First week of December may be different. It will not take much time. You just go through the evidence.
I have already gone.
Yes, and you will. Evidences are in type copy.
Type of it is legible.
Okay. We'll come back at 2. And what is your item?
Okay.
Where is the list? I mix up everything. 10. What is this? 379.
Washing of the judgment of conviction, my lord.
What was, what what was,
Theft of crude oil, my lord. This allegation was that, my
you
lord.
have a difficult case. Isn't it?
My senior will argue. That is.
And what are the next? Okay. Yes.
Entire matter is 11.
Okay, we'll come back at 2. So your methods will adjourn or will proceed?
Right.
Proceed or adjourn?
Adjournment for the-
Adjourn. Or we can take up 2 also if you want to finish it up. Or at
Any other day.
any other. Okay. 21st. Cause list, cause list. আর নাম লেখা যাচ্ছে। Item? None appears for the petitioner on call. List this matter for hearing on give a date. Second of December.
Pass over this matter for a time.
Okay, give a date. Today time being may not be possible. When? 2nd of December. On the prayer of the learned counsel for the appellant, matter stands adjourned and be listed on 2nd of December.
11 also, my lord.
11 of-
For a respondent.
same, isn't it?
Not same.
Not, okay. You are for?
I'm for the petitioner.
Okay, 11 also.
He's on legs before
Okay,
coordinate.
okay.
next matter.
When?
Subject to lordship's convenience.
Will it take much time?
No, my lord, this.
NIX.
is NIX,
NIX.
my lord, yes.
Then give a date. November.
26th, my lord.
26th
the
of
hearing
November.
will acknowledged.
No, 11 হয়ে গেল। Yes.
Petitioner side is not present.
Huh?
Petitioner side is not present. I'm here for beer.
Write down in appeal number 12. Like a common order. None, no, except you write an order. Common order. Huh? This criminal appeal is preferred by convict accused who were convicted by learned special judge CBI Assam. CBI special judge CBI Assam, additional court number 1 Sanmari. in special case number 30 of 2005 date to column by its judgment dated 30/1/2014. Since this appeal was admitted, these appeals were appeals were admitted way back in the year 2014. When this matter is listed today, none appears for the appellants to argue their case. Full stop. Criminal Appeal 116/2014 is being represented by A. Somua, Mr. P.P. Borthakur, MS R. Bora, and Mr. U. Somua. Full stop. Criminal Appeal 97/2014 is being represented by Mr. A. M. Bora, Learned Senior Counsel, D. Gogoi, K. K. Das, MS P. Bhuya, and MS C. Chaudhuri. Full stop. Criminal Appeal number 104/2014 is being the appellant in Criminal Appeal number 104/2014 is represented by Mr. D. Das, Mr. K. Sharma, Mr. A. Hussain, Mr. M. Beria, Mr. K. Chaudhuri, and Mr. K. M. Sharma. Full stop. Criminal Appeal number 124/2024 is being represented by MS N. Thapa and Mr. B. Sinha, and Criminal Appeal AM Bora. Criminal Appeal number 166/2004 is represented by Mr. A. M. Borna, Learned Senior Counsel, Mr. K. Das, Mr. B. Neog, Mr. V. A. Chaudhuri, and Mr. P. Dasgupta. However, none of the associate counsel is present to advance their argument, though Mr. Haloy, Learned Counsel, is present. The Learned Special Public Prosecutor is present. In view of the aforesaid, this court is left with no option but to appoint amicus curiae to argue on behalf of the appellants. Accordingly, amicus curiae list was here only just now. Just now it is. Accordingly, Mr. S. D. Purakayastha, Learned Counsel, is appointed as amicus in Criminal Appeal number 116/2014. Mr. A. Kalita, Learned Counsel, be appointed as amicus in Criminal Appeal 97/2014. Mr. A. Dhar, Learned Counsel, Arunangsu Dhar, Learned Counsel, be appointed as Criminal Appeal amicus in Criminal Appeal number 104/2014. MS B. Sharma, Learned Counsel, be appointed, Vijita Sharma, be appointed as amicus in Criminal Appeal 124/2014. And Mr. Azad Ahmed be appointed as amicus in Criminal Appeal number 166/2014. Full stop. Registry to furnish the necessary documents/papers to the Learned Counsels learned councils, learned amicus within a period of a week from today. Full stop. Thereafter, list these matters in the order column on. Thereafter, list this matter for hearing on. No, will not go to 10th. 10th of December. 10th of December. Full stop. That's all for today. Registry to reflect name of the amicus in the cost list. Court लिखा line लिखितो. In the this court in the given facts ऊपर कर दिया. Also of the tentative view that non-appearance by the learned counsel in a criminal appeal when their names are reflected amounts to a misconduct under the Advocates Act as well as Bar Council of the India Act. However, this court will not proceed further in this regard. Proceed further in this regard.